Hello, good morning, good afternoon, good evening, wherever you're watching us from. Welcome to today's episode of Sadat HR Digest, where we discuss relevant and people organizational topics and help us to impact our organizations positively. Today's episode, we are having a Q&A session, one of the most interesting episodes. I mean, anytime it comes to Q&A, I get excited because we get to learn more. And today, I am excited and privileged to bring two of the seasoned HR professionals that we have in Ghana and beyond to help us respond to our questions and also help us with solutions to some of the things that we are struggling with. Sadat HR Digest is brought to us by Sadat Consult and supported by Quick Fix Creatives. You can contact Sadat Consult on 0244 629245. 0244 629245 for all your people and organizational needs, and Quick Fix Creatives on 05520 90057 05520 90057 for all your designing and printing needs. We want to acknowledge you, and so please drop your name and your location in the comment box. We will read it out and appreciate your participation with us. And also, please don't forget to like, share, and comment on all our social media handles. We are on Facebook, LinkedIn, and YouTube. Please share the link and invite your friends and colleagues and loved ones to join us as we learn, unlearn, and relearn. And please feel free to drop in your questions in case you did not see our artwork to send your questions to us. Don't worry. Feel free to drop your questions. We will read it out to our guests to help us respond to you. And also, you can share your view or your contribution on any of the topics that will be discussed here. Let us know what you think. Let us know your view, and we would appreciate it. Thank you so much. I have Michael Kisi watching us from Kumasi. Thank you, Michael. Michael has been participating Sunday after Sunday, and we really appreciate you. Zachary, thank you. Hey, today Kumasi is raining. Zachary also watching us from Kumasi. Thank you, Josephine. Thank you, Mondi. Josephine is watching us from Takrade. Mondi is from Tema. Thank you, Josephine, Zachary, Mondi. You keep watching us Sunday after Sunday. We want to say thank you. If today is the first time you are watching us on Sadat HR Digest, feel free to share your comments, your thoughts on whatever we are discussing. It's a platform where we learn, unlearn, and relearn. All right, so our guests are ready for us, and so I wouldn't want to bore you with so much introduction and talking. I'd like to introduce them, and we can go ahead with our discussion for today. And so I'd like to introduce our first guest, Mr. Abubakar Kwame Isuman. Is a seasoned and experienced HR practitioner. His experience spans a wide range of industries, including the banking and financial services, telecommunications, trading, and the public sector. He's currently the Director of HR and Administration at Valco. Thank you for joining us, Abubakar. Hi, Abu. Hello, Abubakar.
Hello.
Hi, Abu. Thank you for joining us.
Am I audible?
Yes, you are. I can hear you.
Okay, it's a pleasure to be here. I am always grateful to be able to share my experience, my thoughts with others. Sharing is something I really enjoy doing. So, and of course, I'm also here to learn. Sometimes the comments and questions from others enrich the knowledge we have. So it's a privilege to be here, and I'm grateful for the opportunity.
Right, we are happy to have you here as well. Good to see you. And our next guest is Vera Nuteko. Vera, I hope I got your surname right. An experienced human resource professional with a track record in general HR functions for both startups and high growth companies. She has a widespread experience ranging from mining, construction or real estate, NGO, and the telecommunication. Vera is solid. We've been seeing her on our screen sometimes, and we know that today she's going to support Abu to help answer our questions. Welcome, Vera.
I'm glad to be here. I'm privileged. I must apologize that I think my laptop experienced a challenge, so you won't be seeing my image. But I'm sure for the few who have been with us, at least you know me for now. For the new ones, I really apologize. I apologize. I hope this will be resolved along the line. So I am privileged to be here. Thank you, Pat. And it's a rare privilege to be sitting by Abu to support him, as you rightly said. Thank you.
Thank you, Vera. All right, so Jamel is watching from Accra. Thank you, Jamel Kafui is watching us from Accra. Alice from Taprade. Thank you, guys. Thank you so much for joining us today. So we want to go straight to the discussion, and we have questions that have been submitted to us from some of our co-practitioners or some HR managers and organizational leaders, and they want us to help them respond to these questions. So I want to go straight to the question, and interest in the first question, where the area is so interesting. So the person says that, how would one address a situation of harassment if it occurs outside the workplace but involves employees from the organization or from your organization? How can one address a situation of harassment if it occurs outside the workplace but involves employees from your organization? Abu, can you help us?
Okay. Thank you for the question, Pat. So, of course, sexual harassment is always a very touchy subject. So how do we handle a situation like this? My first prescription will be that every organization must have a policy on sexual harassment that clearly defines what sexual harassment is, the situations that constitute sexual harassment, so that everybody is clear in their minds. Of course, as humans as we are, we can't legislate on every minute detail, but it is good to have a framework. So, for example, I work in an organization that listed the following as situations that constitute sexual harassment. For example, it says when or sexual harassment takes place in the following situations where or at during working hours in the workplace, at work-related social functions, in the course of work assignments outside the workplace, at work-related conferences or training sessions, during work-related travel, over the phone, through electronic media. So these are the places where, if there is unwarranted sexual advances or certain lewd messages or comments about somebody's sexuality are mentioned. So you will find that, yes, some of these situations are outside the workplace, but the key word is they are all work related. So in such an organization, a place like, for example, if you meet somebody at the nightclub or the bar or restaurant, which has nothing to do with the work, and such a situation happens, would that constitute sexual harassment for that organization? Now, per how they have done their policy, the answer will be no. And I will understand why the organization will also be careful to include certain situations that it doesn't have control over. Of course, a criminal activity is a criminal activity wherever it happens. And so I want to believe for this organization, if it is not a work-sponsored event or occurrence and a sexual harassment issue happens, then, of course, within the country, sexual harassment in itself is a crime. So then there is room for the aggrieved party to have some reliefs under the law. But for the company itself, it has to be, the situation has to happen, whether it's off-site or on-site, but related to work. Because there are some that might be very difficult to prove, as it were. And so then the organization might have a difficulty trying to bring such an occurrence within its fold. So in a nutshell, what I'm saying is that, one, the organization has to clearly define this in policy so that everybody is clear in their mind what constitutes sexual harassment and what doesn't. And in cases where it happens outside of the organization and it can be proven. So, for example, through phone call and the person has a recording of it, or through WhatsApp or any other social media platform where there is evidence and it involves two employees, then yes, that can be dealt with by the organization. But of course, I keep mentioning the fact that it has to be within the framework that the organization has set out or defined as sexual harassment. I hope that clarifies the question.
Yes, Abu, thank you so much. Vera, do you want to add up?
Yeah, I'll just add a bit to what Abu has already stated, and I agree with his stance, 100%. And I will cite a very sensitive case as an example. We all heard of the First National Bank issue, where the gentleman in question was a high-profile officer, and the lady in question was, let's say, a national service person at the time, but had left the organization. And so at that point in time, when the lady sued the organization for any form of harassment, the organization clearly came out and distanced themselves from the situation. Because you see, when these things go out, they affect the brand of the organization.
Absolutely.
And they put a lot of, So I would just side with Abu, and then cite this as a typical example of why organizations would distance themselves from such situations when it's not working happening within the parameters that they have described or set as what they will work with in case of any harassment. So basically, that's what I'll add to it. Yeah.
All right, thank you very much. And so the person who sent this question, please make sure that in dealing and handling such situations, it's within the parameters in which you have defined within your policy, your harassment policy, and then it has to be work related. All right, it has to be work related. Right, so I have another interesting question here. An employee who stole from his previous employer and was asked to resign had got another opportunity with a different organization. Now, his previous employer is about to sign a contract with his current employer. And unfortunately, they met the person when they go to the premises of his current employer. They are insisting they will not go ahead to sign the new contract unless the person is terminated. Should the current employer go ahead to terminate his employment to secure this new business, or allow him to go, or allow him to work? So that's the first part of the question. The second part is, if they have to terminate, then what are the best ways, or how best should they go about this termination, since it is not their initiated, like since they are not the people that are initiating the policy and the separation, but it is coming from their partner. How should this be handled? I don't know if you got the person's question. So the person stole from the previous employer, got a new job, and unfortunately for this person, his previous employer is going to sign a contract, give a new business to his current employer. They met him on the premises and they are saying that, right, if you have this person here, we are not going ahead with the contract. Terminate this person before we sign the contract. Can the current employer go ahead to terminate? If they can do that, what is the best way to handle this termination? Abu.
Okay. My take on this question is, one, I will ask the current employer to avail their minds to Section 63 of the Labor Act of Ghana. That's unfair termination of employment. And make sure that if they can prove that this situation will not be deemed as unfair termination, because it is stated that if the employer fails to prove that the reason for the termination is fair, then they will be liable for unfair termination. Now, it is possible to terminate, and let me explain. So, assuming that, one, the question I'll ask is, did the current employer seek reference for the previous employer? That is one. And if they sought reference from them, did this issue come up in the reference? Let's say yes, it came up, and they thought that, well, it's not anything that should warrant the employee not getting the job. So yes, maybe they knew, but they overlooked it, or it did not come up. You know, sometimes when you send reference, you ask certain questions. So if per the questions they put on their form, there was nowhere for the previous employer to state this situation, and so it didn't come up, that's fine. Two, in the course of the recruitment process, was there any point where the candidate was asked why they left their previous employment, and did they disclose? So in this case, if this question was asked and the person did not disclose that, well, I was involved in a theft case, or there was something about theft, and so that is why I resigned. If that came up and he lied or did not disclose, then this will be a good grounds to terminate, because then you are not terminating because the previous employer is asking you to terminate. So here I'm answering the second question. You are terminating because a new information has come to your attention. And so then based on that, you would then have to go through your own procedures to terminate. And the new information is that this person was involved in theft in his previous employment, and he failed to disclose when he was asked. If you did not ask the person this question, so you did not ask, and he also did not volunteer the information, in this case, the person has done nothing wrong. So you will have to, it will be difficult for you to prove that the reason for the termination is fair when you did not ask and the person did not disclose, or there was nowhere in the process where the person was required to disclose. Again, the appointment letter the person has, do you have any clause there that states that if the company finds any information from their past that is they don't know at the present time, then that may be a reason for their employment to be terminated or reconsidered. So for me, the answer is not a yes or a no. Of course, there is a no where the information was available to you and you still decided that you will hire. You cannot, after that, just because of a new contract that's coming up, to say that you terminate the person. However, if the circumstance was such that the information was not made available, even though the candidate had the opportunity to bring the information up and did not, then when it comes up, or the contract is clear that if any information comes up in future, that was not known to you at the employer at the time, you can make use of. So this is how I believe the situation should be handled. Thank you.
But Abu, you notice that most of times when people are asked during interviews why you are leaving your current employer or your employer, it's very difficult for you to get the right answer from them. It has always been, I want a challenging environment. The response to this question has always been the default one, and it looks like people don't really voice out when it comes to some of these questions. I mean, why did you leave and all that? They would want to shield or hide whatever information it is. So in the event, so you spoke about if there was a reference check, usually people have certain default questions they would want to check regarding the candidate. If there was a reference check and that did not toe towards that line, that will be a different issue to look at. Now, assuming it didn't go, the reference check was done, it didn't go towards that direction. Can the previous employer, though was not asked, can the previous employer volunteer this information during the reference check, though it wasn't asked? I don't know if my follow-up question is clear.
Yes. So let me deal with the first part first, where candidates don't give details. You see, and this is advice, free advice to candidates. If you think anything has happened in your previous employment, or even whilst you were in school, that is material. If your current employer or if your prospective employer finds out later in life, please, full disclosure is important. I will advise full disclosure. You see, they may say that, well, it happened in the past. Well, there's nothing, after the role you are coming in, there's nothing to worry about. So let them take the decision that we know what you did and we are okay to still hire you. If you are economical with the truth and it later comes up, you cannot be excused, because then you have failed to state the fact and the true facts as you knew them to be. So on those ones, I will not give you any room to excuse yourself. You had the opportunity. If you were not asked, that's another matter. But if you were asked that, why did you leave? And that is why sometimes some questions appear to be monotonous or not necessary. But please, HR professionals, when you are doing interviews, make sure you ask questions, if even they are not relevant now, but for future purposes, make sure you ask them. So ask the question. Now the onus is on the person to tell you what they want to tell you, so that in future you cannot be cited for not doing due diligence. We should remember that the interview process is part of the due diligence that HR professionals and hiring managers have to go through. Now the issue of, so I am the previous employer of a candidate who is seeking job in company A. They send me a reference, and so the person was involved in theft and he was sacked. So they asked me questions that are not related to the theft. Can I volunteer information? Of course, I can volunteer information. I can volunteer. But if I don't volunteer the information, nobody can hold me for not holding the information. If later the current employer finds out, they cannot hold me that, but why didn't you tell us that this guy was involved in theft? The question was not asked. I didn't volunteer. But if I volunteer information, I've done nothing wrong. And for me, it is when we understand the spirit of the reference check. At the end of the day, I work with a person and I want the prospective employer to know who they are seeking to hire. So it's in my bosom whether I want to volunteer the information or not. If I volunteer, that is good. If I don't volunteer, they cannot hold me accountable for not volunteering when they did not ask.
All right, Abu. We have a follow-up question on the sexual harassment. But before I read that question, let me ask this question. So, on what we are discussing now. So, assuming that didn't come up, previous employer didn't volunteer the information, but now they have gotten to know. If they don't allow this person to go, wouldn't it constitute negligence retention, where they have now gotten to know that this is what the person did, but they are refusing to let the person go? And if if getting to know this, they decide to use this as the basis for the termination, would it have any legal implication on them? They didn't know, now they've gotten to know. Can they use the information now as the basis or the background to let the person go? And what is the legal implication that they are likely to face should that happen?
Okay. Usually when it comes to issues that are hypothetical, it is usually there's no hard and fast rule. But all I will say is that, and I think in my submission earlier on, I did mention even what does the contract of employment say. Employers should always, and that is why employment letters, they are contractual letters. So you have to make sure that your lawyer has looked at. You have some employment contracts that are just one page, scanty, doesn't have anything in there. I usually, when I'm teaching or when I'm training on employment contract, I advise that it shouldn't be just hollow or nothing to speak home about. It should be very detailed. Of course, you can't cover everything, but it should be detailed enough. And there are certain clauses that you can put in there that will, these are like umbrella clauses that you can fit things in future. So my response to your question is that, yes, you can, once the information has come to your attention, you can make use of it, but it has to sit within your internal processes. Don't just say that, yes, if there is nothing in your internal policy to invoke for this new information coming to your attention, then you can be found wanting, or it will be difficult for you to prove that the termination is fair, or you've not doubled in unfair termination. So your internal processes should be clear. The contractual arrangement you have with this person should be clear. So you must invoke something in your internal processes to be able to dismiss the person based on new information that has come to your attention. So all I'm saying is that, yes, it is doable, but how you do it matters. Absolutely. You should remember that process is everything. Procedure is everything. I have seen instances where somebody has stole. This one, the person stole from the company. The person stole from the company. But because the procedure was not followed. The person filed the case at the labor court, and the company was deemed to have terminated the employment unfairly. So if even stealing from you, you don't follow the process, you can be found wanting. How much more stealing from somebody else?
Yeah.
So let's make sure we are following the procedure at all times.
All right, thank you very much, Abu. I have another follow-up question on what we are currently discussing. I want us to, once I read the sexual harassment follow-up question, we'll move to a different question. So we want to handle the follow-up question from Amma on what we are currently discussing, and then we'll move to Mondy's question on harassment. So Amma says, a follow-up question: what if the employee in question did not do anything wrong in the previous company? He or she just left because he or she felt it was time to leave. How would they handle that? Abu?
Okay, so let me see if I understand the question. What the questioner is asking is that the employee did not do anything wrong, but the previous employer is insisting that the current employer sacks him before they will sign the contract. Is that the question?
I guess so.
Oh, this one again. I would say that the current employer should make sure that they are fulfilling Section 63.
All righteousness.
You understand? Because really, even if in the first instance where the person stole, even there I am saying that you have to follow procedure. So if the person did not do anything and it's just a question of because the guy left us, sack him, else we will not sign the contract. I think this one, the new employer should be careful. They should have, or they should let the previous employer know that they have some legal obligations to the laws of Ghana. They shouldn't treat the employment relationships at their whims and caprices. So for me, it's I won't even ask them to even consider, because then in this case, you are putting yourself up for, so the anytime this person asks you to do anything that is even unlawful, just because you want them to sign contract, you do it. No. This one, I won't even ask them to consider.
I guess the previous employer is a jealous employer. So, but I mean, like Abu said, the current employer would have to fulfill all righteousness. And he said something. He said, "Process is everything." You may not have a case, but as maybe your employee may not have a case, but if you don't handle the process or the procedure well, the whole thing can turn upside down. So please make sure that your processes are in place and you have the right processes you are following. If not, what should go in your favor would go against you. Thank you very much, Abu. Right, so let's take Mondy's question, and Vera will help us to respond to this question. She says, what if the sexual harassment is work-related, but there is no policy?
Okay, right. Thank you, Pat. If it is work-related and there's no policy, there's a whole body of knowledge out there. There's a whole international, law of bodies out there that you can fall on. So as an organization, you cannot condone or allow this just because you don't have a policy. In fact, it is an opportunity and time for you to revise your policies and put something in place after you have handled it. So I would say that by all means, handle it and employ whatever policies are, let's say LIs or body of knowledge that is out there to help you resolve it. So by all means, resolve it, and then review your policies to reflect that.
Right, review your policies to reflect
the little
that.
I'll add to this. just to add to this, so as Vera said, so for HR professionals, anytime you don't have policies on anything, first ask yourself, is it covered in any law in your country? So that you are not breaching any law. If not, refer to ILO standards, the International Labour Organization, so that at least you know that you are following some best practice. So that's the bit I would like to add to various submission.
Yeah. And like Abu said, I think the last time we were on set, we said that there are a whole lot of other regulations that HR practitioners are not using, even within Ghana. We are just so focused on Labor Act. And even with the Labor Act, some people don't look at it at all. They just ask questions in the air and then they expect to get answers from everywhere. But it is important that we become practitioners who are referring to laws and regulations from all over the place to help us to enrich our organization and ourselves as well. So let's take note of that. Yeah.
Let's be practitioners who are referring to regulations everywhere. Don't just stick to one. We have a lot. Please get copies if you don't have. Now, when you go online, you can have all these acts and allies over there that would help you in your practice. And when you are developing your policies, make sure that you are working or your policy is in line with the labor regulations and laws in your country, wherever you are. Don't just put in anything there that you feel or think should be there. Make reference and make sure that you are doing the right thing. Jamal says that I'm enjoying this talk. This is my first time. Thanks to the organizers. Thank you, Jamal, for joining us. We are happy to have you here.
Yes, before you proceed, okay, I think when you were talking about this issue of the theft case, the issue of asking for reference from the organization come up. I think most of the reference requests I have seen, mostly at the tail end, people will just put in any other information that you think that is relevant for us to know. So that is a point at which you can reflect, you can recall or tell whatever additional important information that the current employer will need to make a decision. So I think that bit of a question should be taken very seriously by practitioners. And this part of our world as well, some people are very protective. The cultural aspect of our dealings with people doesn't allow us to want to talk. So when you talk about it, the person won't get the job, so we want to shield and do ABCD. But really, we need to get to a place where we move from there, because this is a business, a typical business case, which can harm another organization. And so it's important that we begin to volunteer some of this information, but not with malice, with the right intent, out there. And I would say also that I recall a candidate called me and said, I'm going for an interview. And in my previous employment, this is what happened. And I'm afraid if they ask me, what should I say? If I do not say it and they find out, what would happen? And I told the person, just like Abu rightly said, I would rather advise that you say it. It is better you say it. Let them understand. Maybe go back and find out from your employers and do whatever checks they want. If they still want to go with you, you are free. But if you do not say that and it comes up later, it would be worse off than you could have even imagined. So luckily she went, she said, well, nothing was asked on that. She's got the job and she was happy. But if it had come up, at least I'd advise that she let it out. Really. So I think it's important, like Abu said, that we should open up and say it as it is. But sometimes it has happened, you've learned your lessons, you've turned over a new leaf, you've done so many things. You have to prove that. And then maybe a good employer will want to say, okay, let's give you a chance and see how it goes. So just a bit to add to it. Yeah.
Right. Thank you, Vera. Just feel free to voice out so that in future, if it's found out, you have already given that information. And it's very important for us to also carry ourselves very well when we are working, wherever we find ourselves, because you never can tell the future. And so when you find yourself at a place, be careful how you behave, be careful what you do, be careful what you say, because one day it can bite you in future. Be very mindful. And I think if we are all mindful and we are all careful, on how we conduct ourselves and how we behave ourselves, we will not be even be talking about this issue in the first place. So let's be mindful. All right. So there's a question from Zachary. Zachary says, can an organization's policy supersede that of the labor law? Can organization's policy supersede that of the labor law? Abu.
No way. No law or no regulation can supersede the law of the land. So that is a no. Sometimes what happens, the Labor Act is it's not detailed, or it doesn't go into the nitty-gritty of the issue. So they give a framework. So an organization can form policies that fleshes out the meat, but you can't have any policy that goes against the law of the land or an act of parliament. It's I think that's what the lawyers call ultra bias or something like that.
All right, thank you very much. Abu, so we want to take this question, and then when we are done, we would go for a quick break, and when we come back, we will take I don't know whether I should pronounce this name as a word or as initials. So or ARM will take your question when we come back. All right. So Vera, so this person says, what is it okay to encourage workplace relationship? What can employers do if this has to be encouraged?
Okay, great. This is a dilemma for most HR practitioners and organizations. Mostly people will say no, and others will say yes, but on conditions, right? So there are organizations that actually have policies that says no, you can't do that. So you can have that in your policies that says that we do not want this, in the organization. But there is also the situation where people allow it and then they put measures in place to control. Because, for instance, if you want to encourage that, then you should also be mindful of the fact that there are different departments or divisions of the organizations, and there are certain information that should not be shared anyway anyhow. So having people have that kind of relationship within the organization can compromise some of those information. So for instance, you have maybe a director of finance with his assistants being his wife or whatever. Can you imagine what can happen to that organization? So ideally, you want to say that, okay, if you want to have that relationship, come clean with it. Once you come clean with it, what we can do is that your two of you must not be in the same department. So that is what some organizations have done. So in fact, even having somebody in IT, okay, and then having maybe a finance person with a husband and wife, and the let's say the director of finance has gotten himself into trouble that needs to be retracted. Can you imagine what can happen if the pillow talk comes in? So these are things that we need to take very seriously, entrench them in our policies. Let people know what we expect of them, and then what would happen if in one such instance, what they put in as their policy was that once you find out that you are in a relationship and you're going to take it serious, then one of you must resign. That is one aspect of it. And then, like I said earlier, other organizations will say, okay, you can do that, but you cannot also be in the same department. You have to be in different places. So what you do right from the attraction and recruitment stage is that some of these questions can be some of the filtering questions, not that you deny the people, just so you know, so that if the people are applying to the same department, you know how to handle that. So that is one aspect of it that I've seen a couple of recruitment advertisement. Okay, when you are using the online tracking system, that those questions come up. Do you know anybody? How is the relationship with that person? So they know right from there. And such organizations definitely know that they cannot discriminate against you based on the fact that you know somebody, but it's for an informed position, so they know how to handle you coming in where the position you are applying to. But of course, once even you know somebody in that organization, and that person in the organization knows that you cannot come into the same department as me, I am sure that if you're applying for the same thing within the household or outside, the two of you will know that this is not going to pick unless you lie. And if you lie about it, eventually it will come up. You cannot hide it forever. So I think it's a matter of policy. The organization needs to decide what is good for us, how it will affect us, the business and relationship in the organization, and then entrench it in the policy. So it's neither a no or a yes. It can be based on policy, basically.
Wow, it has to be based on policy. Organizations must decide whether it's good for them or not. Abu, what's your take on this question?
Okay, so I agree with Vera 100%. There are risks for allowing couples, and not even just couples, even siblings, to be in one organization. And so you will know, or you should identify what those risks are. So for example, collusion can happen, favoritism, nepotism, these things can happen. So what mitigation do you put in place to make sure that even though you allow in your organization, you have proper mitigants in place? You can, so as Vera said, some organization will say no, maybe they cannot, they don't have systems to mitigate, so they don't want to even go there. But when some organizations will allow it but put mitigants in place, for me, it's not whether if you allow it, you are a good organization, or if you don't allow it, you are a bad organization. If whichever way you decide to go, make sure you have the right policies, and most importantly, you apply the rules across the board consistently with no discrimination. Okay, not that for Kofi and Ama, because of the role they handle, if we don't allow it, the company will suffer. So we allow for Kofi and Ama. But when it came to Ajua and Kwame, that one, no. If they are not holding any important role. So for them, the moment you begin to do that, then you are going into the realm of discrimination, and that is what will not be good. So decide on what you want to do. Make sure there's a policy to enforce that, and you are good to go. Thank you.
Right. Decide on what you want to do, but make sure there's a policy and be consistent. And your policy must apply to everybody. Don't discriminate. If you are doing it for A, make sure that B also goes to the same thing. Thank you very much, Abu. We'll go for a quick break, and when we come back, we have 2 interesting questions in the comment section. We'll read it out, and then we will take one more question and bring the discussion to a close. We have a lot of questions, so hopefully next week we would continue with Q&A discussion. I think the last time we had 3 weeks to discuss questions, so I'm hopeful that next week we would continue with the discussion. So let me read this out before we go on break. Daniel says, Abu and Vera are really on top of issues. Glad I'm here. Thank you so much, Daniel, for joining us here. We'll go for a quick break, and when we come back, we would take some few questions and then bring the discussion to a close. Hello, welcome back. This is Sadat HR Digest, and today's episode we are having a Q&A session with two seasoned and experienced HR experts, Abubakar Kwame Isuman and Vera. Thank you so much. In fact, I'm enjoying the discussion, and I hope our viewers are also enjoying too. If you just join us, please feel free to post your question in the comment section. We'll read it out for our guests to respond to us. If you are not able to answer your question today, next week we'll come again and continue. And so please feel free, let us know what your question is. Let us have your thoughts on the discussion, and we would read it out. Knowledge is sharing is caring, and all that, Charlie. We are here to learn, unlearn, and relearn. And I would like to also remind you of our HR analytics workshop. We had people requesting that we have it online, and so we have listened to you. We are a listening organization, and so we've listened to you. We are having our HR analytics workshop. It's an online workshop from 23rd of June to 25th of June. It will be done via Zoom. And what are your takeaways from this workshop? You will get HR analytics tools and templates, HR metric templates, certificate of participation, after training support in HR analytics, and then you would also have networking opportunities with other HR practitioners. You don't want to take yourself out of this. It's very, very, very helpful. I have personally participated in this training, and trust me, there are a lot of things I can do now. Don't just make decisions based on feelings, but make sure that your numbers are speaking for you. And so please join or register for this training, and let's learn a lot. Let's learn here. Right, so let me take Mondi's question. I think she posted it earlier on, has reposted again. I'm going to read that for you. Mondi said, how do you ensure compliance with statutory issues for a company which has been operating for like 2 years, example SNIT, but concern about the cost implication? So if I understand the question very well, they are looking at the cost implication or the cost in paying SNET and other statutory obligations. And so because of that, they are having issues with it. I don't know, maybe massaging figures here and there. She's asking, how do you ensure compliance when it comes to such issues? Abu, you want to help us with this first?
Thank you, Pat. Okay, so basically, somebody is breaking the law. Please, we can't. For me, the only advice I will give is that we shouldn't break the law, even when it comes to tax. Tax evasion is unlawful, it's illegal. You can do tax avoidance, which is well and good. So you may need to probably get a tax expert to tell you, okay, these are how you can pay less tax, but still within the law. But when it comes to statutory payments like SNIT, if you are not paying somebody SNIT, you are basically shortchanging the person. That one, I don't know how else I can say it. And you see, they should be careful. Sometimes people will blow the whistle on you. Yes. If they know that you are not paying, they will blow the whistle on you. And maybe now you think you are making less money, or if you pay the statutory payment, you make less money. But what if your company is closed down? You see, that is the other alternative. Your company can be closed down.
Absolutely.
So for me, I don't think I'll give any room, or I'll leave any room for anybody to decide whether they want to pay or they don't want to pay. These days, even house help that we have in our homes, even the law requires of us to pay SNET for them. How much more an organization that is working and making money then you say that because of cost implications, you are trying to avoid. No, that is a no-no. So the HR, if there's an HR professional in such an organization, they should go on record, at least write a paper on that to management for them to know that what they are doing is unlawful, and state what the consequences are. Okay, very, and even if the person in charge of finance, if that person is where they are sought, if they supervise over such doings, they can even lose their license. That is if they are chartered anyway. So let's not condone such acts that blatantly disregard our laws.
Let's not condole on such acts. It's a no, 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 no. This one, I don't even need to ask Vera her take on it. It's a no, no.
Absolutely.
Don't break
It's a
the
no.
chain.
It's sad that people even consider some of these things, unfortunately.
And I guess the finance person there doesn't know what he or she is about. I mean, if you are a finance person, an experienced one, and a well-trained finance person, you should know that this is a no, 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 and you don't have to encourage this unless you are under duress to do this. And if that is the case, then please, if I were you, I'll take my bag and leave before before the law catches up on me, because this is a no. I mean, you don't have to condone such a thing. All right, so let's read the last question on the comment section, and then I would come to one question I have here, and we'll end for today. We'll continue next week. I promise you, we are going to, because there are a lot of questions we need to answer. And so I promise you we'll continue this next week. So it says, what happens to a staff who does not come to work for almost 1 week without permission? Can we issue him a letter to end his probation with us? Hey, you're on probation and you're not coming to work. Vera. Abu is shaking his head.
Wow. The person is on probation and they're not coming to work. So you see, like
For 1
Abu
week
said,
without permission.
for 1 week. Like Abu said, what is in your policy? What have you put in there? So, so when some of these things happen, it's an opportunity for HR practitioners to begin to review their policies. So this is a matter of policy, and the law rightly gives the employer the right to determine how the employee-employer relationship will go. So one of the things, it's absenteeism has a way, or tardiness has a way of affecting productivity, and even affecting other employees who are watching on if you don't do anything about this. Most organizations have policies in place that says that absenteeism for so many days is equal to probably termination or this sanction or the other. Most often you'll find people say 5 days, 2 weeks, whatever. Within that period of absenteeism, the policy would say that you should reach out to your your line manager or the HR if you have a peculiar situation. So maybe it's a case of illness, it's a case of something has happened which has made it impossible for you should reach out. But if you do not reach out and it is found out that it's just a case of truancy, it's just a case of being absent for no reason, then of course your employment has to be terminated. More so, this person is on probation. Usually on probation, I mean, the most people would do is 2 weeks of notice. So if you've been gone 1 week, then there's nothing holding on to this to the employment relationship. So please, let's entrench in our policies what we would do to such, do in such situations when employees try to take advantage. There are places where you find employees know that, 5 days, they say 5 days. So by the 5th day, I'm back at work. And then you will see that it's something they do. they go and do maybe some by day job somewhere, get more money. Then by the 5th day, they are back at work because they know that by the 5th day is when you sack them. And it's important that as HR practitioners, we monitor some of these things. We have to train our line managers to monitor some of these trends so that when you observe that this person likes to do these things, they don't have any reason, they don't have any reasonable cause for staying away. It's just that they are playing the system, and employees can do that a lot. They will play the system. So let's have policies that says that you cannot stay away for so long without cause and then come back and play as if everything is okay and we continue like that. So I think it's a position of policy that we need to entrench, and that is what I'll say. I'm sure Abu has more to say on that.
All right, it's a position of policy. Abu, what's your take on this question?
So I agree with Vera. I think it's about time HR practitioners make sure there are policies and procedures for managing the workforce. This question wouldn't have come up if those procedures or the policies were there. Straight up. In everywhere I've worked, there is no notice period for when you're on probation. In fact, the employee can decide to leave without giving notice. The employer can decide to terminate without giving notice when you're on probation. And that is what is in the policy. So for somebody, and such a person knows that, again, there is policy on if you cannot come to work, what you have to do. The onus is on you to reach out to your employer or to your supervisor. I'm wondering, of course, maybe you traveled somewhere and your phone, the battery died and you are involved in some accident or something, and but definitely your employer will try to reach out and find out. That's why when we come to work, we are filling forms, we are asked to who is our other next of kin or contact person in case of emergency, blah, blah, blah. So any responsible employer will try to reach out and find out why this person has been absent for 1 week. In fact, if there is no reason why, and as Vera put it, if it's just truancy, we don't have to give you any notice. Per practice, everywhere I've worked, the policy is clear. On probation, there is no notice. So even if we want to give you notice, maybe just courtesy, we tell you nicely that, well, this one is called you have absconded. So if you abscond, you want to stay at home, so we'll help you.
Is it our
all right?
Thank you. But I mean, let's be careful how we behave at the workplace. And like Abu said, maybe you have traveled, your battery went off, your phone, or you had an accident, nobody heard of it, but is your family not aware? So if in such situation your family will be aware, why wouldn't you get the same information passed on to your employer? Please, let's not force employers to do things that they don't want to be doing. If you push us, we'll do it, please. All right. It's not a good thing to be doing. Okay, so let's take we'll take our last question, and then we'll go to our guests to give us their final words, and we would end for today. So this person says, as HRs, we ensure staff, including management, adhere to the policies in place. In a case where an employee commits a minor offense, such as giggling during a meeting, one will expect that the employee's attention will be drawn to that to avoid interruption during the meeting. However, management feels for them to send a message to the office they decide to suspend that employee instead of giving a verbal warning as the first action for such an offense. Now, the staff in general have lost confidence in the management or in management. Management is now requesting to review the existing disciplinary policy so it has room to suspend at will, even for minor offense such as above. They have been made aware it's not the best practice and to comply with the policy. However, they are adamant. What will you advise is done? I don't know if you get the question.
Yes. So, okay. I thought you. So let me respond. So basically, what I make of this question is, sometimes senior management or management may want to do certain things that are either against the Labor Act or against best practice. In this case, yes, it's against best practice. And as HR professionals or practitioners, it's one of our responsibilities is to speak truth to power. Sometimes even at the peril of our own jobs, but you are not disrespecting anybody. You are stating the professional position and the implications thereof if the right thing is not done. We should remember that the employment relationship is not servitude. It's so somebody brings their labor, another person brings their capital, and so that is what the employment relationship is about. If any organization wants to be an employer of choice where scarce talent, because talent is scarce, really. If you want the best people to work for you, then you must have the best and the right policies. So in this instance where you want to put in policies that are inimical to the employment relationship or to how employees fare in the workplace, what you seek to do is to drive employees out of your organization, or better still, even those who will stay will be disengaged. And nobody wants to have employees who are disengaged, because once employees are disengaged, they are doing their barest minimum so that you cannot sack them. But they are not working to go beyond and above their call of duty that will bring you the productivity that will result in the profitability you want. So you don't want to do that. And that is what I expect every HR professional, the case to make when some of these issues come up, where borderline, they are not breaching the law, but they want you to do things that are, for lack of a better word, cruel. Okay. So for me, it is speaking truth to power, making sure that you are making the case, especially since the question is saying this is not best practice. So you have to look within your industry, what are other companies doing? And you are in the same job market with those same companies who do similar things like you do. So at the end of the day, you cannot be an outlier where your practices are so off that your employees, when they compare themselves with what their colleagues in other similar companies find themselves in, will not say that they are going through worse situations. So for me, my advice would be that you need to make a very strong case not to have such a policy in place. I was going to say initially when the question started coming up, I thought maybe there was no policy, but if they are now asking you to even amend the policy to bring this draconian measure in place, then it's what you need to do is to make a case, of course, with proper data, having done some survey of similar companies and what pertains there, and to make sure that this does not become a reality, because it will result in high staff attrition, which will affect the company bottom line in the long run. So, sometimes or most times management understands bottom line. Employers understand bottom line. So if you can relate issues to the bottom line, then you'll be speaking their language. And sometimes that's the language HR people don't usually speak. We have to speak the language of senior management so that they understand issues from their perspective. And this issue can definitely result or affect negatively the bottom line of the company in the long run. So that is what I'll advise the HR person to do.
Thank you, Abu. Management understands bottom line. Employees understand bottom line. Let's learn to speak the language of the bottom line. Vera, what's your take on this?
Yeah, Pat, you see, I can smell that there is the cooking of a toxic environment if they are not already in there. And all management wants to do is to entrench that position of a toxic environment. And like he said, management understands the bottom line, but sometimes they don't know what it takes to maintain that bottom line. So it's a responsibility of us, the HRs, to draw their attention. Like he said, present cases, present situations, and let them understand that these are the resultant effect of what they are asking you to do. So one of the things you can do as a way is to gauge the climate, the employee climate, and also use it as a case to prove. Then some of these things, eventually what will happen is that we are used to absenteeism, but there's also something called presenteeism.
Yeah.
So people will be coming to the workplace, but really and truly, they are not doing as much as you expect them. They are not going over and above themselves. So let's be careful what we are made to entrench in our policy so that we do not harm the organization, because we think that let's be in the good book of management. No. Eventually, if a case comes up, you'll be surprised that that same management will say that you did not advise us. You understand? So let's be bold. Let's state our case in a very nice way, and then let's get the right things done for the employees and also eventually for the organizations. So that's what I would support with. Yeah.
Let's be bold, let's state our case, and let's get the right things done. Thank you so much, Abu. Thank you, Vera, for coming today. It's been very insightful, and I guess my viewers have learned a lot, as well as myself. I've really enjoyed this session, and I can't wait for next week. We want to wrap up, but before we say bye, we want to have your final words and we can end for today's session. Vera.
Great. So we've been saying again and again and again, the policies are not something that we carve out of anywhere. They are just the various rules and regulations around us. So you want to be an employer of choice. How do you become the employer of choice? It's by way of how you treat your employees. It's by way of the policies you've churned out there. So we are encouraging HR professionals. Don't be afraid to speak the truth. Just speak it right. Speak it with figures, speak it with numbers, data, whatever you can do, just to convince management that, listen, if we need to maintain this bottom line, if we did A, B, C, D, by virtue of research out there, by virtue of leading organizations out there, this is what we would, achieve. Then, of course, I'm sure over time, I know because I've been there, over time, you earn the respect and you begin to make impact and improve the system for the betterment of both the employees and the employer. Let's not forget, the employer-employee relationship is not servitude. It's an exchange of resources, basically.
Right. Thank you very much, Vera. Abu.
Thank you, Pat. I share all that Vera has said. The only part I'll add is that as HR practitioners, we are the conscience of the organization. If we lose that conscience, then the employees will not have hope, especially for if your organization is not non-unionized. Then it's important that you become that conscience for them. You become that person who, yes, you are not there to give in to every request employees make, but to make sure that by your actions and your doings, the employment relationship is kept professional. Laws are respected, and the company is not taking undue advantage of the employees. And also, even if you are working in a unionized environment, you become that professional who is representing management, such that when you meet with the unions, you are able to have a conversation and you are able to build a partnership with them in the workplace. That is what an HR practitioner is expected to do. I read an article by Dave Ulrich, who is one of the professors in Harvard. And the article was on fearless HR. And it talks about the fact that, yes, as an HR practitioner, you are also an employee, first and foremost. But if you fail to speak truth to power, if you fail in your role to represent the employees in the boardroom where it matters, if you fail to bring the relevant issues to the table for fear that you yourself might lose your job, then you will not be performing your role as an HR practitioner or professional. So that's what I'll leave with all of us. Let us play our role. At the end of the day, if nobody can speak on a particular matter, and it happens all the time, even executive committee members will come to you and tell you that, Charlie, you are the HRO. When you go, you have to say it. Meanwhile, they are part of executive committee, huh? They are looking up. So if you don't have that fearless personality to bring the issues, and as Vera said, you are not going to say it just because, yes, I'm fearless, so I come and stand there and I'm talking. No, you are speaking with data, with facts, with information that you have gathered, that you are presenting to management in a language that they understand. That is our job as HR practitioners. Thank you very much.
Thank you very much, Abu. Thank you, Vera. Let's be fearless HRs, and please remember that you are the conscience of the organization. If you lose that, I don't know what else you would want to be for your organization. It's been very insightful. Josephine says, it's been a fruitful discussion. I have learned a lot today. These are realities we face at work. Thank you, Mr. Isuman and Madam Vera. Let's do this again. Definitely, we are going to do this again. Thank you, Sedat Consult. Thank you, Josephine, for your comment. All right. So the contacts you requested have been shared with you. Thank you so much. Mondi says this session has been so insightful. Thank you so much. Thank you to Mondi. Thank you everyone for joining today. It's been very insightful, and we promise, and as requested by Josephine, we are going to definitely do this again. We'll see you next week. We'll continue with our Q&A session with HR experts. Come, let's learn so that we can help the organization and help the people we manage. My name is Patience, and I've been your host for today, and I'm going to be your host for next week. This has been Sadat HR Digest, where we discuss relevant people and organizational topics and helps issues. We discuss issues that helps us to manage our organization and also speak the language of the bottom line. I'll see you next week. Please take care and don't do anything that will bring you any harm or anything that will bite you in future. Thank you and have a good evening. Bye.